So, Jason, you've had an opportunity to review these motions that were recently filed. They appear pretty standard boilerplate, but what is the function of these?
Well, so there's three different motions. One is a request for discovery. The other is called a motion in limine, and the third is a motion to suppress. So there are three pretty standard motions that defense attorneys will file in any criminal case. You're right; they are boilerplate, but they do have some. They have some pretty important role to play in the future criminal prosecution as the case moves down the as it moves through the court.
Talk to me about that role. I mean, the facts of the case that, as we know them so far, are that Mr. Cotter is alleged to have hidden an illegal firearm for his longtime business partner, Brad Simpson. And in an arrest affidavit for Mr. Cotter, states that he gave investigators permission to look at his call history with Mr. Simpson and then also text messages with Mr. Simpson. So how might these motions, particularly the motion to suppress, for example, come into play down the road?
Sure. So it's pretty important. One of the things, two of these motions, so the discovery motion, we'll just start with that. Everybody has to ask for it. That's how you get the discovery from the prosecution. They need, obviously, any attorney would need everything that the prosecution has in order to defend their client. So that's what that is. Specifically, though, with the motion in limine and the motion to suppress, as you just talked about, the motion in limine is important because even though it doesn't say much there, what it's saying is Judge, before trial, we want to have a hearing. And I think what they're going to end up specifying is they're really going to try to limit out anything that Mr. Simpson is alleged to have done, because that would obviously really prejudice Mr. Cotter, right? So you have one defendant that doesn't want anything in his trial having anything to do with somebody alleged to have killed their wife. And so a motion in limine is when you go to a court and say, Judge, before we even start this trial, we want you to limit the prosecution to not bring in all of those facts from that case into this case because it would prejudice this case. And we're only talking about this thing. So that's where the motion in limine is going to come in play. It doesn't say all of that in the motion right now, but one of the things judges do is that they go, okay, you've given us your basic, which kind of holds the place of, okay, we understand that we know we're going to have to argue about this. Tell me specifically what you're asking to exclude. So when you kind of see like any prior bad acts or anything of the defendant, what they're really going to do is hone in, I'm sure, because I would if I were representing them, I'd hone in on not having any of that other case there. As far as the motion to suppress, you were right on with that. The motion to suppress is asking the court to not allow evidence in a trial in front of the jury. So in this case, we're talking about a firearm, an illegal firearm that was alleged to have been hidden on behalf of Mr. Simpson. Well, that firearm, they're going to say, well, the reason that you were able to get in there and even talk to my guy or get into his house and find the firearm or question my guy at all, question my client, all of those things, you violated the Constitution somehow. Either when you were questioning him, you were doing it and he wasn't voluntarily talking to you, you were questioning him under duress. It could be that they didn't get a warrant proper, like they didn't do the warrant properly. And again, that motion to suppress doesn't say all of that now, but what it is it's holding a place, and the judge is going to ask when it becomes time for trial for at some time before the trial to make it specific, tell the court exactly what you're asking me to exclude. And if the court granted a motion like that, the court could theoretically say, we're not going to allow the prosecution to talk about this firearm or to talk about finding it or where they found it. And in that case, the prosecution, the state would have to dismiss the case, as well as anything he said. If something that he said led to text messages or phone calls like you were talking about, if they make the argument that it was not voluntary on Mr. Cotter's part, then, and the judge goes with that, then the court can exclude any of those text messages back and forth. And so, it just kind of depends on, I don't know, I'm not the lawyer on the case, so I don't know exactly what their strategy is, but those are the kind of things that if you're trying to get something out or exclude something with the court, you have to file these motions in order to get there.
You brought up something very interesting with the motion in limine. How does, I mean, you've been a prosecutor and you're also in criminal defense now. How do you not bring up, like you had said, nobody wants to have the facts of a guy who's alleged to have murdered his wife, seep into their own case, for allegedly hiding a firearm. How do you find that balance? And can you even? Uh,
Yeah, I think that's where the argument's going to be, right? Because if I'm the prosecutor in this case, I'm like, absolutely, to give context to why he's hiding this firearm here. You have to talk about everything that's going on. But of course, the defense is going to say, well, nobody's alleged or proven or shown that this firearm actually did anything over there or was a part of that case over there. And you could theoretically try it in a silo and just say, this guy has possession of an illegal firearm. And so that's really what we're asking. That's really what we're talking about. That's what we're alleging. And if that's what we're alleging, we can try the thing on, did he have possession of this firearm without even going into any of that other stuff? And so the main balance that the court has to strike and what the law says is the law says that any of that other stuff from the other case, if the prejudicial danger, and basically what that means is if by bringing in that other case far outweighs any of the actual relevance or the probative value that it has, then the court must exclude it. And so what that really means is if the jury would convict this guy, this defendant in this case, based upon the alleged actions of another defendant in another case, that's not a fair trial. So basically, the judge will have to make that balance. Now, court could say, you know what, it's so relevant and so probative to what we're trying to do here and to explain the actions and explain the motive, so relevant that even though there is unfair prejudice, it doesn't far outweigh that relevance. It doesn't far outweigh it. And so I'm going to allow it in. And I just see it as a court could kind of go either way. In the defense attorney's job, if that's what he's going to argue, the defense attorney's job is to really try to carve it out as specific as possible so that he can fight any of the prosecutor's allegations or the charges that hey, we have to consider all this at once. Because if you're a prosecutor, that's basically how you want to try the case. You want to say, look, we've alleged this guy over here killed his wife, and then he helped him hide this firearm over here. And that's going to make your case much better. But for me, if I were a prosecutor in this case, I think what I would be doing is really trying to come down on this guy on the firearm, so that because I would figure as a prosecutor, if he helped this guy hide a firearm, what else did he help this guy hide? And you really try to pressure this guy and put as much pressure as you can to bear on him to see if he will come out with something that may help you with the other case, which is obviously the more important case to them.
so if they do go off of this, say the judge sides, with the defense and says, okay, you can't mention this, wouldn't they lose their tampering with evidence charge if they're not allowed to really get into what investigation
It's
this was hidden connection to?
That's a great argument. I mean, so that's what the prosecution is going to be doing. So for me as a defense attorney, what I would say is we will stipulate there is an investigation ongoing. We will stipulate we will say we agree there's an investigation ongoing, but we're not going to talk about what it was, and we'll agree that you don't have to prove that part of your elements. All you have to prove is that I hit it with the intent to hinder that investigation, right? So only the other parts of it. So that's the strategy back and forth, and a judge may buy that or not. A judge may say, no, I'm not. I'm going to allow them to try their case. This is the case that you were tampering in, and everything else. But it's kind of like somebody who has a DWI, who has 3 DWIs, right? If you don't want the jury, if let's say they've actually had 5 before, and so they're charged with a DWI third, but they've really had 5. Well, if you don't want the jury to know that he's had 5 prior DWIs, you say, look, we'll stipulate that this is his third DWI, right? And in that way, the prosecution can't then go back and go through each and every DWI. So what you do is you agree to something in order to limit them from going into the details of it, because it can be so prejudicial.
So this is really a negotiation between both sides. Both sides have a lot to give or keep.
Yeah, and that's where the judge earns their money, right? Because that's the judge's job, is to say, all right, I'm listening to you. I'm listening to you. This is what I think is the best decision under the law. And however that comes down. And then of course his papers get graded in the Court of Appeals and even up further. So the judges are always thinking about those things, like what is actually right with the law. And then the two advocates are going to be advocating for either part and either side.
Okay, last question from me. This motion for discovery, it kind of seems like on its face, wouldn't the state have to turn all of this over? There's some things, criminal records of each witness that they intend to call, things like this. Kind of seems common sense, but talk to me a little bit about why it's necessary to be specific in what you're asking for.
Sure. So Article 3914 of the Code of Criminal Procedure, it's really come a long way in the last, 10 years or so. But what it still needs and what it still requires is you have to make a request under 3914 to get all of the protections and the discovery protections under it. So these discovery motions are not usually not even motions that a judge is going to rule on. It's something that we point to later and say, look, we asked for this and we did not get these things, and we asked for it under 3914. 3914 requires that the prosecution give all of these things to us, and we've actually made that request. So really it's one of those things that the defense attorney wants to make sure is part of the court's file, so that 3 years down the road when there's a trial and we don't have something, that we can look back and the court can look back and say, well, they did ask for it, and then we can start making decisions and the court can make rulings about what they're going to do to rectify the situation.
Excellent. And you've had this happen in some of the cases that
Yes, and
you
that discovery motion saved us, because the judge looked back and went, no, Mr. Goss asked for that, and so therefore, you should have provided it. And that's what the attorney in this case is doing, and making sure that he's got, all those bases covered as far as that goes.
okay. That's really it for me. Like you said, it's unlikely that the judge will rule on this discovery motion, but the other stuff, does the judge have to hear these motions or
So yeah, usually, so a motion in limine is always done traditionally before, either right before we pick a jury or right after the jury gets selected, unless the motion has something to do with how the jury's being selected. So for instance, if the attorney said, Judge, we need to hear this beforehand because I'm afraid that they're going to even talk about this in jury selection, then the judge would want to hear that beforehand and make a ruling. And that ruling simply says you can't just blurt it out. You have to come up, approach the court, remove the jury from the room, and we have to argue it and discuss it before anything can come into evidence. So it's basically telling both sides, don't mention it, don't talk about it unless you come to me first, and I have agreed that you can do it. And that carries on throughout the trial. So if halfway through the trial I feel like, well, now this is relevant, this other investigation, this other part. The judge told me I couldn't say it in the first part, but I would approach the court and say, Judge, we'd like to address this issue outside the presence of the jury. So that's what a motion in limine does. The motion to suppress can either be done on a separate motions hearing or setting before trial, or it can be run with the trial, which means that before that evidence can come in, before the statements can come in, before whatever they're trying to suppress can come in, the judge can make a ruling that it either is or is not going to be able to be brought into evidence. And so usually judges, especially in cases like this, like all the things to be done pre-trial, so everybody is on the same page and they understand exactly what the trial is going to look like and what evidence is going to come in and what isn't. But some judges, depending upon how they feel about it, can run that motion to suppress with trial, so you wouldn't see it done until after the trial starts.
awesome. That's it for me. Is there anything you'd like to add that I didn't ask?
No, no, I appreciate you talking to me and
Awesome.
yeah, yep.
And likewise, let me stop.